You're watching Notepad and I am Ibrahim Sani. What a week it has been. We've seen a trifecta of events unfolding right before us. The crash of the oil price, Dow Jones and also KLCI actually taking a dip, and a few other challenges that are currently happening in court. Most notably is of Datuk Sri Najib's lawyer being quarantined. But it's not just that is currently happening in court, in the courts right now, because one of the bigger events impacting corporate Malaysia is, of course, the ongoing MyCC, or Malaysia Competition Commission, and their battle with Grab over an 87 million ringgit fine against Grab. Of course, to recap right now, Grab Holdings, along with its subsidiaries, Grab Cars, Nabahat, and MyTaxis Nabahat, is currently in view or in focus of being anti-competitive. And because of this, earlier this week, MyCC has kind of had an upper hand because of a court challenge where the case has been set aside by the courts. So joining me this particular evening is Nahendran Navaratnam of Navaratnam Chambers to help me understand a little bit better about what is currently happening right now with the Grab situation. Nahendran, thanks again for taking the time to speak with us.
Thank you very much for having me.
Let's do a quick recap into what this is all about before we jump into what just happened earlier this week.
All right. What you had was a proposed decision that was delivered by the MyCC against Grab, contending that there are practices in restricting Grab drivers from allowing the advertising content within their vehicles for competitor providers was not permitted. So an investigation ensued initially based on a complaint that they received. The allegation by Grab in part of this challenge is that investigation was what they would call a roving investigation. It started off with an investigation into one matter, then it evolved into something else, and they were never clear throughout that process what the investigation was really directed at, until they received the proposed decision, which said, we now feel that you have abused your market position, your dominant position in the market by imposing these restrictions. And we want you now to immediately remove the restrictions. We are going to hit you with the possibility of a fine for each day that you do not remove these restrictions. We require you to notify all your drivers that these restrictions are no longer enforceable. And that was all done in what is known as a proposed decision. So I think the problem really was that the impression is that they have been hit with penalties for conduct which the MyCC believes to be in breach, even before they have been given the opportunity to make the representations that they are allowed to make under the Act in order to reverse that decision.
Okay, so I just want to be careful about the whole situation, because this is still an ongoing case.
Sure.
So let's look at how this events transpired across the timeline, right?
Yes.
Because on 26 March 2018, Grab and Uber merged. And shortly after that, we saw MyCC saying that they will investigate into the matter. That alone is an interesting discussion point. Why do you think that MyCC feels that they need to investigate the whole Grab-Uber merger?
Okay, one of the major things in competition law is when persons are in dominant market positions. So obviously when two of the same service providers merge into one entity, they become even more dominant than the two used to be when they were separate.
Okay, but we have that in other industries.
All you do, yes, you
Banking, there was an amalgamation of a bunch of banks into, right now we have about 6 or 7 or 8 banks. Telcos, same thing.
Right.
Broadcasting industry.
Yep.
We've seen this across many sectors in terms of amalgamation and mergers.
Right.
Why is it that Grab and Uber is the one that is under scrutiny?
Well, number one, I think because the market is much smaller. With banks, you've still got competition in the market. It doesn't mean that MyCC doesn't look at those bank mergers and ask themselves the question that they should be asking themselves. Does this place you in a dominant market position? And the next question is, are you abusing that dominant position? So obviously they must have felt the minute there is a merger of two of the major service providers in that sector of the economy, you immediately become a target for observation. Then they will start to ask themselves, well, are you using your dominant position in an abusive way? Are you rigging prices, for example? Are you pushing up the cost because you have a dominant position? Everybody has to buy your services, and so there's no competition, and therefore you can push your prices up as indiscriminately as you like. So they will look for those sorts of things. And I think that's what prompted the investigation. I don't think there's anything wrong with what MyCC would have done there, because any small number of players in a small industry, or an industry that is controlled by several small players, when they merge, will immediately attract that kind of attention.
Okay, so now we're looking at, say for instance, July 2018, where MyCC has announced that they want to investigate into the merger. A little over a year later, around October 2019, you were mentioning about the proposed decision that MyCC has, I guess, imposed upon Grab.
That's right.
The imposition, is it warranted? Do they have the power to tell Grab what to do? Because they are, after all, a commission.
Yes, this is where I think the concerns of Grab may have come about. The proposed decision, the way the Act is structured, MyCC does the investigation. It goes before the Commission. The Commission decides, I think there's some basis here. They write out a proposed decision. The way the Act works is the proposed decision is then put to the parties that are concerned. The proposed decision must contain enough information to enable you to answer the charges. And that is what a proposed decision is meant to do. Now, if subsequently you're supposed to have either an oral hearing or a representation in written form to the Commission, and the Commission then decides whether to maintain its decision or to dismiss it. So it's a slightly different scenario from the way ordinary prosecutions of offences occur.
Okay, when you say slightly different,
right?
I mean,
in what way?
In what way?
Okay, let's take a criminal charge. The police investigate a charge against me.
Okay.
They then make a recommendation to the Attorney General. The Attorney General says, yes, I think there's enough here to prosecute him. They institute a charge. My lawyers then find out about it. They turn up in court. We hear the evidence, and then the judge, an independent person, makes the decision. Okay. All right. And the judge has no interest in the outcome of the suit.
Okay.
Okay. Now, in this case, you have
this is time immemorial. This
that's
has
right.
been around what, Magna Carta.
Absolutely,
yeah,
absolutely.
Okay.
Now, in this case, you have the people who investigate are MyCC. The people who decide whether or not there should be a charge, in that sense, proffered against the company is the MyCC. The person who decides whether the charge is worthy of conviction is the MyCC, and the people who collect the fines are also the MyCC. Now that's how the Parliament has structured the Act. So you can't complain about the way the Act is structured, because that can only be done by Parliament if they're going to change it.
We're talking about the Competition Act, 2010?
That's right.
Very, very, very new Act.
Very new Act, yeah. So that's the way the Act is structured. Now what does that mean? To me, it means that, look, the MyCC, because they are the investigator, the prosecutor, the person who decides, as well as the person who benefits from the collection of the fines, that places them in a four-pronged position of sensitivity, in the sense that because they are so caught up in the benefits that come from this investigation and this prosecution and this decision, they owe a much, much higher duty to be seen as independent, to be seen as fair, and to be seen as complying with what we in the legal industry call the rules of natural justice, which is essentially the rules that you must be procedurally fair in everything that you do.
So they have to cross the T's and dot the I's.
That's right.
As best as they could.
To a far greater degree than another decision maker would.
Okay.
Because of the peculiar position they find themselves in, because of the general way in which the Act has been
Is
drafted.
there any recourse if
Judicial review.
All right.
And that's what Grab have done.
Okay, so let's recap. So on 30th December, Grab filed for an application for leave to commence the judicial review in the High Court and Grab has submitted a written representation to MyCC.
Right.
And this was done on 30th December last year. And earlier this week, we saw that judicial review being set aside.
Okay, not entirely. What happened was Grab have the opportunity to defend themselves against these accusations by way of the Section 37 and Section 38 representation process.
Okay.
So you've got the proposed decision that comes out, and the reason it's called a proposed decision is it's provisional.
So when do we have like
Right?
a final
The final decision happens only after Grab is given the opportunity to be heard. And that was the issue that actually the court dealt with. On the one side, MyCC said, look, why are you taking us to court now? Why can't you wait until after the representations are made? Give us a chance to review the decision the proposed decision that we have made in light of what you are going to tell us at the written representations and the oral hearings that will follow. And if we agree with you, we will set aside our decision. That seems a perfectly reasonable approach. So on the other hand, Grab is saying, hang on a minute, why do we need to wait for those representations to be finished? Even though we have a chance to talk about these things and defend ourselves, we are still exposed to the fact that we have to correct our behavior now. We have to expose ourselves to fines or daily fines that will be imposed as of now. And therefore, we are justified in going straight to court rather than through the ordinary process set out in the Act.
Okay.
So that's the balancing act that the judge had to look at, I think. And obviously the judge felt that at this stage he was not prepared to allow Grab to make those arguments. He said, you go and make those arguments at the representation stage before the commission. The court is not interfering at this stage.
Okay.
Now,
so that's what happened.
That's what happened. So Grab can still make the arguments that they want to make at the commission stage, the argument, and complete that entire process. Then after that, there's an appeal process, which is also stipulated under the Act, to what is known as the Competition Appeals Tribunal. And it is after that that they then have the potential for judicial review. So the real question was, why did Grab bring that judicial review process forward?
Okay.
Right, rather than wait till later.
Yeah.
And that's what the judge meant, I think, when he said this matter is premature.
But again, you're speculating in this sense.
That's
you're second guessing.
Well, I think that can be the only conclusion, that when the judge said premature, that's what he must have meant.
Okay.
That it's why come now rather than wait till coming back later.
Right. You were mentioning about tribunal. So who is inside this tribunal?
There are quite a few members. I can't name them offhand, but
but the rules, I guess. Are they from ICC mostly? Or
no,
what?
they are separately appointed. One of them, the chairman, has to be a former High Court judge, or a High Court judge, or a former High Court judge. And then there are several people. There are 2 economists. There are some lecturers.
Okay.
So it's a fairly well constituted body.
Okay.
So and they will hear the appeal.
Yeah, it can be seen as a fair body to listen to appeals.
Yes.
All right. Not a punitive body where
that body is completely separate from the commission itself.
Okay.
So you've got the commission investigating, prosecuting, deciding, and then there's a right of appeal to a completely different body who can hear the appeal and hear all of the matters that you feel were lacking in the original process. And that is why I think the judge said, okay, maybe this is premature. Now, from Grab's perspective, I mean, just looking at it from a general perspective, from an academic, because I don't have intimate details of what Grab's arguments are or what MyCC's arguments are. So I can only comment generally. And I don't want to make any comments about whether the judge got it right or the judge got it wrong. I can only say, all I can say is that I think this is what must have been meant when these observations were made.
Because you can help me walk through the process.
That's right, and so can the listeners sort of understand what does this really mean. So I think from Grab's perspective, the reason they may have argued that this matter should have been dealt with now, as opposed to waiting until the Commission's actual decision, which means the proposed decision then becomes a final decision.
When is this supposed to?
That's when the written representations and the oral representations are concluded. You remember we talked about they came out with a proposed decision in October, and then in November or December. They filed something.
Yes.
That was their arguments to overturn the proposed decision.
Okay.
And that hearing has not taken place yet.
Okay.
So they put in that, that argument to convince the Commission that they've got it wrong in the proposed decision.
Right.
That's why it's a proposed decision.
Yeah.
It's not yet final. He said, look, I think you're
So
guilty.
MyCC in a way can still
Reverse itself.
amend,
Oh yes, they can.
reverse, whatever.
Vary,
or add even.
add even.
Okay.
Difficult to add because once I've charged you with the offence, I can't, after I hear what you have to say in your
then
defence, suddenly change the
moving the
change,
goalpost
move
lah.
the goalpost. That's right.
Okay.
But they can change their reasoning. They can, within limits,
Okay.
they can change their reasoning. They can dismiss certain portions of the findings. They can agree, for example, that the penalty we impose may be too extreme. We will give you a smaller penalty.
Yeah, but how does one decide whether a penalty is harsh or not harsh enough? Or I mean, isn't it a subjective argument? Is it based on earnings or something? I don't know.
The penalty, the maximum penalty the Act permits is 10% of your worldwide revenue. Now that's the maximum penalty. So the MyCC has anything within 0 and the maximum penalty to play with. And naturally, normal sentencing policies will apply. How egregious was your conduct? How many people did it affect? How much money did you make out of the egregious conduct?
Correct.
So all of those things are factors that they will look at and they will balance when they make the final decision. And those are matters which, of course, are dependent on evidence. Okay. So Grab's problem, I think, was this. They said, before you've even heard us on any of this, you've imposed us with a daily penalty.
Right.
That daily penalty can possibly be reversed on the appeal. Sorry, not on the appeal, but when the hearing takes place. But we are still exposed to that potential now. And by imposing it in your proposed decision, you've placed a great deal of commercial pressure on us. At the same time, you've also told us that whatever we are guilty of in terms of imposing the advertising restrictions on our drivers, you are forcing us to reverse it now, even before we've had a chance to defend ourselves.
Okay.
So in that sense, they are contending that MyCC has acted in abuse of its powers.
But let's look at some of the precedent cases similar to this. I tried my best looking at fines, amount of fines that is being imposed prior to it being heard in the proposed decision.
Yes.
Can't find any actually.
I think there was one instance.
67 million ringgit worth lah.
That's right. I think there was one instance where they imposed something. I can't again offhand tell you which one it was. I think there's only one other instance where the MyCC has imposed a penalty of sorts within the proposed decision itself.
So it has happened before?
It has happened before. I don't know whether they challenged it, and that I think that is why Grab have decided, if these sort of things are happening not just to us, but to other industries or to other players in the market, perhaps we should try to put a stop to this kind of thing.
See, the thing about MyCC is that they are representing me and you.
Yep.
They're representing the people of Malaysia
That's
against activities that are being deemed as anti-monopolistic.
Right.
So I guess, in a way, shouldn't I back MyCC in their efforts to clamp down on monopolistic behaviours?
Oh, absolutely, provided they do it in accordance with what Parliament has enacted.
Which is by far the way you presented it.
Yeah.
It's quite...
Well, they are within their rights to make the arguments that they have, and it's really for the courts to decide whether they have exceeded those boundaries or not by imposing penalties at this stage, when they really should have waited. They could have said, we propose to impose these penalties at the final decision stage, to give you an idea what kind of penalties we're going to seek so that you can defend yourself.
Okay.
But why did they impose the penalties immediately?
So what is the meaning of this judicial review being set aside?
In judicial review, what it means is that when public decision makers, people who make decisions in the pursuance of public functions, like MyCC or any other
whatever,
whoever,
Swaka,
right?
whatever.
That's right.
Right.
They must act in accordance with the law, right? Now, the courts presume that they have acted in accordance with the law, unless you can show me something that demonstrates that maybe there's an arguable case that they haven't. So in judicial review cases, there is this leave stage that you have to go through. You have to go to the court and say, Judge, there is this act, there is this organization, and they have breached their powers under the act, for example, or they have abused their powers under the act. And the judge will scrutinize it and say, perhaps you've got an arguable case. If you've got an arguable case, he gives you permission to file judicial review. That's what they call the leave stage. That's what happened here. They went to court and said, we would like you to look at the proposed decision that that has been made against Grab, and we invite you to conclude that there have been certain inconsistencies with the legal requirements along the way. And the judge looked at it and says, I don't think you've made out a prima facie case, and therefore I'm not giving you leave. Now, the threshold at that stage is very low, just a prima facie case, just something that looks as if there might be something arguable.
Grab didn't even pass that
They didn't even pass that part, that threshold.
Yeah,
yes.
the threshold.
So that means that it's been dismissed on a very low threshold.
Okay.
And that is why Grab, I think, have decided to say, well, look, if the threshold is so low, and I still think there's an arguable case to be made here, I think I want to appeal.
This is exactly what happened.
That's
Grab
what's
has announced
happening.
that they want to appeal on Wednesday, I think 2 days ago or 3
That's
days
right.
ago. When this is happening, what do they go to court of appeal, or is there
Yes, they go straight to the Court of Appeal.
Okay, we'll take a short break. When we come back, we'll discuss a little bit more about the meaning of this towards the industry. Don't go anywhere. Thanks for staying on with us. I am with Nahendran Navaratnam talking about MyCC and Grab, but let's understand this a little bit more in terms of the Competition Act, because again, this is a rather new act. It was enacted in 2010, and it's currently being, I guess, tested in the courts. What does this mean for us trying to understand MyCC's role in their pursuit of clamping down on anti-monopolistic behavior? In your opinion, do you think that there is a time and space for us to actually amend the Competition Act to allow for more parties to be involved in the judge, jury, prosecution role?
Well, I think the MyCC can actually do a lot even now. If you look at developments in the UK and India,
Without changing the Act?
Without changing the Act.
Okay.
Because the Act actually permits them to set out guidelines. Now, in as much as they can issue guidelines to tell the industries that are concerned how they should conduct their affairs, they are also empowered to issue guidelines to set out how they should conduct their own affairs. And one of the things I would strongly recommend that the MyCC look at is guidelines to demarcate the differences between the prosecution and the investigation side, the decision-making side, and perhaps one area that Parliament should look into is that the funds that are collected by MyCC shouldn't be managed by MyCC.
Okay.
It should be managed perhaps independently by the Ministry of Trade or something of that nature.
Transport, whatever.
Yeah,
LSDN.
and that actually removes one area of what we call policy bias or conflict of interest bias. Because if I am interested in the money that I collect in fines, I will do my very best to collect as much money as I can. That places me as a decision maker in a position where I am interested in the outcome of how much money I collect, as well as interested in convicting as many people as I can.
But they're just operating within the law.
That's right. But the law actually has placed them in this conflict of interest position.
Yeah, so it's not their I guess.
It's not their problem.
Not their problem.
I agree. If Parliament says I can do it, why shouldn't I do
right
it?
here. Read it.
Right. But But overriding all of that is this principle that the courts will always require bureaucrats to make their decisions in a fair manner. So if I have got, the more power I have, the more the obligation upon me to act fairly.
So you're saying that it is in their best interest to actually reduce that obligation.
To reduce to increase their thresholds for fairness.
Yeah. And by default, reducing the obligation to actually perform with a lesser scrutiny.
Correct. So you see, at the end of the day, it's like this. If I have a tremendous amount of power, and people will look at me and say, well, are you exercising that power fairly? The more power I have, the more room there is to say that I am not exercising that power fairly. And there's always a court that's overlooking what I do and making judgments about whether I'm acting fairly or not. So if I want to protect myself against those accusations, what do? I put into place systems that make it look optically as if I am in fact being fair. So if I have the power to investigate, prosecute, fine, judge and then fine, should I not internally break up these functions so that there is a demarcation within my own structure, and when people make the accusations of policy bias or conflict of interest bias against me, I can say no, I've actually guarded against that accusation by creating systems within my own structure.
The bodies, when they have their rights enshrined in a particular act, it is not in their interest to break up this particular function because it works in their favor. Therefore, the pressure now comes on us, the people, putting the necessary pressure on our elected officials if we have some. Right now, there's a mess right there to begin with.
Yeah, of course.
But if we haggle our MPs and get the Dewan Rakyat to, I guess, improve on the Competition Act,
that's right.
Isn't it in our best interest to make it happen as well?
Absolutely right. I mean, I think it must be two-pronged. The institutions must recognize that if I have these powers, I must exercise them fairly. I've got a court who's going to oversee what I'm doing and expect certain standards from me. Why don't I meet those standards now, even before somebody challenges me? Which is what they seem to have been looking at and doing in India and in the UK. There also they have got wide powers, but they've told themselves, we will impose guidelines on ourselves in order to meet those expectations of the law. But yes, as ordinary people, we also owe an obligation to lobby the parliamentarians to do the right thing.
All right. Lovely, that was my conversation with Nahendran Navaratnam talking about Grab and MyCC. If you've missed any part of this interview, just head on to Astro AWANI and look for Notepad over there. You can find these interviews and interviews such as this on our website. Thanks very much for watching and goodbye. Thank you.
Thank you very much.